Hello friends, welcome to Defense IAS Academy. Today we are going to discuss about fundamental rights, articles 12 to 35. Part 3 of the Indian Constitution consists of article 12 to 35, which deals with the fundamental rights. The part 3 of the Constitution is called the cornerstone of the Constitution, together with the part 4. And now, why is this fundamental rights important for the UPSC exam? Under the considering the UPSC exam, we can say that the fundamental rights are a very important topic in the polity section of the UPSC exam. It is basically a static portion or a static syllabus, but it has a very highly dynamic sense of nature. Mainly it has daily news that are coming up, which you can relate with the articles 12 to 35 and in some form or another, and it is very important for the IAS exam. So come on, let's discuss about the articles 12 to 35 of the fundamental rights. Uh, the fundamental rights, what is a fundamental right? A fundamental right is a basic human right that is enshrined in the Constitution, Part 3 of India, which are guaranteed to all citizens. So it is a basic human right that is enshrined in the Constitution of India, which are guaranteed to all citizens of India. They are the part 3 of the Constitution is described as Magna Carta of India. It means it is very important part of the Constitution of India. Now, the fundamental rights, the ideas or the concept of the fundamental right is taken from USA, where it is called as Bill of Rights. The as we discussed earlier, Part 3 of the Constitution is called as Magna Carta of India. Magna Carta, the Charter of Rights issued by King John of England in 1215, was the first written document relating to the fundamental rights of the citizen. Now, this fundamental rights are applicable to all the citizens of India without any discrimination on the basis of race, religion, gender, etc. So, this fundamental rights are enforceable by the courts and subject to certain conditions. So, why are they called fundamental rights? They are called fundamental rights because of two reasons. One is they are enshrined in the Constitution, which guarantees them. It means that the fundamental rights are guaranteed by the Constitution to all the persons and the legal entities without any discrimination. They uphold the equality of all individuals, the dignity of the individuals, the larger public interest, and the unity of the nation. Second, second reason for calling them fundamental right is they are justiciable, that is enforceable by courts. In case of any violation, a person can approach the court of law. The word justiciable says that it allows persons to move the courts for their enforcement if and when they are violated. The fundamental rights are named so, that is like justiciable, so because they are guaranteed and protected by the Constitution, which is a fundamental law of land. Now, what are the list of fundamental rights that we have? There are 6 fundamental rights that are mentioned in the Constitution of India. Uh, but originally, the Constitution classified fundamental rights under 7 groups. Now there are only 6 groups. Right to property was removed or eliminated by the 44th Amendment Act in 1978, and it was transposed to a new article called Article 300A, which is not part of constitution. Part of means It's not part of part 3 of the constitution, but it has been labeled as an part of the chapter 4 of part 12. It is not a fundamental right. It's no more the right to property is no more a fundamental right. Now, other than that, what are the 6 fundamental duties that are there or that are mentioned in the Indian Constitution? They are right to equality, right to freedom, a right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So these are the 6 fundamental rights that we have as Indians. Now, among these fundamental rights, some are for Indian citizens alone, means only for Indian citizens, and some both for Indian citizens and foreigners. Now, the fundamental rights are from Article 12 to Article 35. So, in that, the Articles 15, 16, 19, 29, and 30 are applicable only for Indian citizens, and the fundamental rights that are under the Articles 14, 20, 21, 23, 25, 26, 27, and 28 are available for all residents of India and also foreigners. Similarly, we can say that some fundamental rights are negatively worded as prohibitions of the state, like Articles 14, 15 of 1, 16 of 2, 18 of 1, 20, 21 of 1, and 28 of 1. So we can sometimes the fundamental rights are also negatively worded. Now, let us see all the rights one by one. So this picture says the parts of constitution. We have part 3, 4 and 4a. In that the part 3 is one we are discussing about, which is the fundamental rights. It is also called the Magna Carta of India. It has articles from Article 12 to 35. It is borrowed from America and France. It is borrowed from America and France, and it can be suspended during emergency except the Article 20 and 21. And the fundamental rights are available not only to Indian citizens but also to foreigners. And as I said earlier, the Article 15, 16, 19, 29 and 30 are only for Indians, not for foreigners. They are only for Indians. Now, what are the fundamental rights that we have? We have 6. The right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. Now, under each article, we have subdivisions also. Now, the articles start with Article 12 and ends with Article 35. Now, the Article 12 and 13 can be called as the introduction of the fundamental rights. So, they can be called as introduction of the fundamental rights, and Article 12 mainly is used to define the state. It defines a state which includes the government of which includes government and the Indian Parliament, then government and legislature of the states, and the local and other authorities that are in the territory of India, and also the authorities which are under the control of government of India. So here we can discuss this picture in detail later. So here, just like an overview, I'll tell you an overview. We have articles 14 to 18 which says about equality before law and equality protection of law. Then we have articles the article in Article 15 says prohibition of discrimination on grounds of religion, race, sex, etc. Then Article 16 says equality of opportunity in public employment. Article 17 is abolition of untouchability. Then Article 18 is abolitions of the titles. Then we have articles 19 to 22. So please go through this picture so that you can get an idea of the articles in one gesture, rather than reading the entire text or the notes. So always pictorial representation is a very easy format to keep things in mind, or to register things in mind. So next we'll see the right to property. We'll just talk about the right to property, which was abolished from or removed from the fundamental right of the Constitution. Now it was deleted from the list of fundamental rights by the 44th Constitutional Amendment. This was deleted because it became a hindrance towards attaining the socialism and distributing of the wealth, that is the property, equally among the people. So the right to property is now not a fundamental right, it is a legal right. So what are the fundamental rights? So as I told, fundamental rights are written from articles 12 to 35. So what is in article 12 says? Article 12 defines a state, means it defines the state as a government or an Indian parliament, or it can define the state as a government and the legislature of the states, or it can say that state is local and other authorities which are in the territory of India, or it defines state as a local or other authorities that are under the control of government of India. Now, Article 13, it confers to the power of judicial review to the courts of all legislative acts. The Supreme Court of India and state high courts have a power under Article 32 and 226. They can declare an law unconstitutional if it is inconsistent with Part 3 of the Constitution. Power of judicial review makes the Constitution legal. Power of the judicial review makes the Constitution legalistic. Now, we can say that the Article 13 gives liberty to the citizens of India, and it actually protects them from being infringed by the state. This article protects the individual's fundamental rights by rendering any law null and void if it intervenes with the liberty or is inconsistent in any way with the fundamental right of the person. Next is the right to equality. The articles 14 to 18 says right to equality, right to equality, the fundamental rights, right to equality. Now, the articles starting from 14 to 32, they are very important, or the most important of the fundamental rights. As I said earlier, articles 12 and 13 is like an introduction of the fundamental rights, and the articles 33, 34, and 35 means the last three articles, they can be told as conclusion of the fundamental rights, and the very important fundamental rights are from article 14 to article 32. So, the right to equality, the first fundamental right, it is described from the articles 14 to 18. Right to equality guarantees that everyone get equal rights irrespective of their religion, gender, caste, race, or place of birth. Means everyone is treated equally in regard to the or irrespective to the religion, gender, caste, race, and place of birth. It also ensures equal employment opportunities in the government, and it ensures against discrimination by the state in matters of employment on the basis of caste or religion, etc. This right also includes the abolition of titles as well as the untouchability. Next is right to freedom, which is described from articles 19 to 22. Freedom is one of the most important ideals that is cherished by any democratic society. The Indian Constitution guarantees freedoms to its citizens. The freedom right includes many rights such as the right to means the freedom of speech, the freedom of expression, then the freedom of assembly without arms, freedom of association, freedom to practice any profession, freedom to reside in any part of the country. So these are the freedoms that are given to the Indian citizens through the fundamental right articles from 19 to 22. Some of these rights are subject to certain conditions of state security, public morality and decency, and friendly relations with the foreign countries. This means that the state has no right to impose reasonable restrictions on them. So likewise, though every citizen has the right to all these freedoms, but they are all subject to reasonable restrictions, such as they should not cause any public nuisance or disorder, and the freedom should not violate any other's right to freedom, and freedom is not unlimited right to do what one wants, and the government can also impose a certain reasonable restrictions in larger interest of the society. So that's about the right to freedom. Next is right against the exploitation. So the articles 23 and 24 say about the fundamental rights, right against the exploitation. The right implies a prohibition of traffic in human beings, beggar, and other forms of forced labor. It also implies prohibition of children in factories, etc. The Constitution prohibits the employment of children under 14 years in hazardous conditions. So, the Constitution says that there should be no trafficking of the human beings, that is selling and buying of human beings, generally women and children, and there should not be any forced labor or beggar in any form is illegal and is prohibited. Then the child labor is also prohibited. Then the Parliament of India has enacted laws to implement constitutional right that prohibits children above children below 14 years of age from working in hazardous industries such as bead making, firecrackers, and matches, printing, dyeing, etc. So, the Constitution of India provides distinct and clear provisions to prevent exploitation of a weaker section of the society. So, next is the right to freedom of religion, which is described from the Articles 25 to 28. This indicates the secular nature of the Indian polity. There is equal respect given to all the religions. There is freedom of conscience, profession, practice and propagation of religion. The state has no official religion. Every person has the right to freely practice his or her faith, establish and maintain religious and charitable institutions. The articles 25 to 28 say that the individuals have the freedom to live by their faith and religious beliefs and practice as they interpret these beliefs. So they can actually profess, practice and propagate their religion. Then we can say that every section or every religious group is free to manage its religious affairs, but is subject to reasonable restrictions also. And you can say that this right is in form of restrictions upon the government not to compel any person to pay any taxes for the promotion or maintenance of any religion or religious institution. India is known as a secular state, which means that the state has no official religion, and India does not promote or protect any one religion over the other religion. Next is the cultural and educational rights, which is described from the articles from Article 29 to 30. These rights protect the rights of religious, cultural, and linguistic minorities by facilitating them to preserve their heritage and culture. Educational rights are for ensuring education for everyone without any discrimination. So, the right to the educational and the cultural rights. The cultural and educational rights also say that any section of the citizen with a distinct language or culture has the right to conserve its language, culture, and religious practices. So, the democracy is based upon the wishes of large majority. So, in this system, the right and interest of the minorities need to be protected by developing a mechanism that cannot be changed prejudicially by the majority. Therefore, in a democratic country, special protection is provided in the constitution to preserve and develop the language, culture, and the religion of the minorities. And next is the right to constitutional remedies, which is described in the articles from 32 to 35. As I said earlier, the last three articles 32 to 35 sorry, not 32 to 35, 33, 34 and 35 is something as like a conclusion to the fundamental rights. Now the right to constitutional remedies 32 to 35. The constitution guarantees remedies if citizens fundamental rights are violated. That government cannot invade upon or curb anyone's rights. When these rights are violated, the aggrieved party can approach the courts. Citizen can even go directly to the Supreme Court, which can issue writs for forcing fundamental rights. The enforceability of the rights is a very important aspect of the fundamental rights, and hence it is called as the right to constitutional remedies. According to Dr. Ambedkar, the right to constitutional remedies is the heart and soul of the Constitution. Now, as we discussed, like citizens can go to court, which can issue writs for enforcing the fundamental rights. So what are the writs that are ordered by Supreme Court or the High Court? There are five types of writs that are ordered. One is habeas corpus. It means that the court orders that the arrested person should be presented before the court. The court can also order to set free an arrested person if the manner or on grounds of arrest are not lawfully or satisfactory. Next writ is mandamus. This writ is issued when a court finds that a particular office holder is not doing legal duty and thereby is infringing on the right of an individual. Third writ is prohibition. This writ is issued by a higher court, that is High Court or a Supreme Court, when a lower court has considered a case which is going beyond its jurisdiction. Next writ is quo warranto, which means that if a court finds that a person is holding office but is not entitled to hold that office, it issues this writ and restricts that person from acting as an office holder. The fifth type of writ is certiorari. Under this writ, a higher court orders a lower court or another authority to transfer a matter pending before it to the higher authority or court. So these are the things that comes under the right to constitutional remedies. Now, what are the features of the fundamental rights? The first one is protected by Constitution. The fundamental rights are different from ordinary legal rights in the manner in which they are enforced. If a legal right is violated, the aggrieved person cannot directly approach the Supreme Court bypassing the lower courts. He or she should first approach the lower courts, and then by step they go to the higher courts. Some of the fundamental rights are available to all citizens, while the rest are for all persons like citizens and foreigners. So the first feature of the fundamental right is that it is protected by the Constitution. Next is fundamental rights are not absolute rights. They have reasonable restrictions, which means they are subjected to the conditions of state security, public morality and decency, and friendly relations with the foreign countries. So we can say that fundamental rights are not absolute rights. So the fundamental rights of the people are not absolute rights, except the right against untouchability. They are qualified with the limitations and reasonable restrictions in the collective interest of the society. So these rights have been laid down for protecting the public health, the public order, morality and security of India. Some exceptions are also provided to fundamental rights through their non-applicability to members of security and law and order related forces during martial law and for certain laws necessary for socio-economic reforms. Now, the third feature of a fundamental right is they are justiciable, implying that justiciable means they are enforceable by courts. people can approach the Supreme Court directly in case of violation of a fundamental right. Justiciable rights means if any of these rights are violated by the government or anyone else, the individual has the right to approach the Supreme Court or High Court for the protection and enforcement of his or her fundamental rights. So the Constitution not only grants but also guarantees these rights. There are elaborate instruments to protect these rights, such as right to constitutional remedy, public interest litigation, human rights commission, etc. Next feature is the fundamental rights can be amended by the Parliament by a constitutional amendment, but only if the amendment does not alter the basic structure of the Constitution. So, means the fundamental rights are amendable. The fundamental rights are amendable, meaning they are not permanent. The Parliament has the power to amend any part of the Constitution, including the fundamental rights. The fundamental rights, despite having inviolable nature, can be amended by the Parliament, subject to the basic structure of the Constitution. We can say that the Parliament has exercised this power on several occasions. Next feature is that the fundamental rights can be suspended during a national emergency, but the rights guaranteed under Articles 20 and 21 cannot be suspended. So the Constitution can provide a suspension of all or any of the fundamental rights during an emergency. Such an suspension automatically ends when the emergency ceases or when the President withdraws it. Next feature is the application of fundamental rights can be restricted in an area which has been placed under martial law or military rule. So the laws can be restricted in areas where there is military rule or martial rule imposed. Next, we can see what are the fundamental rights available only to citizens. So what are the available rights, fundamental rights for the citizens of India and not for the foreigners? Prohibition of discrimination on grounds of race, religion, caste, gender or place of. The Article 15 says that the discrimination on grounds of race, religion, caste, gender or place of birth is prohibited. Then the equality of opportunity in matters of public employment means everyone is given an equal opportunity in matters of the employment. Then protection of freedom, the Article 19 says protection of freedom. What all freedom they are given: freedom of speech and expression, freedom of assembly, then freedom of residence, freedom of association, freedom of movement, freedom of profession. Protection of the culture, language and the script of minorities is also mentioned in the Article 29. Now, the right of the minorities to establish and administer the education institutions is mentioned in Article 30. Now, let's see a few questions that can be asked on the basis of the fundamental rights that we have discussed so far. The first question is fundamental rights gets inspired from what? The correct answer is USA Constitution. So the USA Constitution is called as Bill of Rights. So the concept or the theory of fundamental rights is taken from the USA Constitution. Next question. Fundamental rights is called as fundamental because the choices are they are protected by the Constitution, they are essential for all-round development of an individual, they are protected by the judiciary against legislative and executive arbitrariness. Now the correct answer is 1 and 2. 1 and 2 are the correct answer because fundamental rights are called fundamental rights because they are protected by the Constitution, and two, they are essential for the development of an individual. Question number 3. Identify the right choice about fundamental rights. 1. They are not absolute but qualified. 2. They are available against arbitrary actions of the state. 3. All fundamental rights are positive in nature. 4. They are not sacrosanct and permanent in nature. The correct answer is option C, 1 and 2. Means only 1 and 2 given in the question is correct. Next question. Indian Constitution defines parliamentary democracy as 1. People representation in the government. 2. Responsible government at central and state level. 3. Accountability of council of ministries to government. The correct answer is option B, 1 and 2 only. Means the 1 and 2 given in the question are correct. That is the people representation in the government and responsible government at central and state level. That is the Indian Constitution defines parliamentary democracy as the people representation in the government and responsible government at central and state level. Question. Right to education is part of what? The right to life, cultural and educational rights, freedom of speech and expression, right to equality. The answer is option 1, right to life. It is part of right to life. Question 6. Which fundamental right was removed in 1978? The correct answer is option 2, right to property. Next question. The madrasas are not under the preview of right to education because of which article? The article number is article 30. The correct answer is article 30. Question 8. Right to vote is dash. It is a constitutional right, it is a fundamental duty, it is a fundamental right, or it is a legal right. So what is right to vote? The answer to this question is it is a legal right. Idea of judicial review under Article 32 is taken from British Constitution, USA Constitution, 1935 GOI Act and Canadian Constitution. The correct answer is to USA Constitution, the judicial review. The idea of judicial review is taken from the USA Constitution. Next is reasonable restrictions on the fundamental rights can be imposed by whom? Who is responsible for imposing reasonable restrictions on the fundamental rights? The correct answer is the Parliament. The Parliament can impose restrictions on fundamental rights. Question 11. Right to privacy as fundamental right declared by the Supreme Court of India under which article? So, right to privacy is coming under which article? The answer is Article 21. So, Article 21 says about the right to privacy. Question 12. To enforce the fundamental rights, writ can be passed by whom? Is it Supreme Court or High Court or Central Administrative Tribunals or district courts who enforce the fundamental rights? Uh, writs 11 means who imposes writs. The correct answer is option 1 and 2, that is C. Option C is the correct answer, 1 and 2. Supreme Court of India and High Court of India means the most powerful courts in India. Supreme Court and High Courts, they can pass the writs to enforce fundamental rights. Question 13. Fundamental right can be suspended during emergency by whom? Parliament, President, Supreme Court of India, Council of Ministries led by the Prime Minister. Who is responsible for the suspension of fundamental right by an emergency? The correct answer is the President. So the President is the one who is capable of suspending an emergency that is coming. It's not like emergency, it's like they can suspend a fundamental right because of an emergency. Question 14. Which of the following is not a fundamental right in the Constitution of India? Which of the following is not a constitutional right in the Constitution of India? The answer is 1 and 2. That is, right to reservation and right to work are not a fundamental right. Next question 15. The Supreme Court held that fundamental rights are amendable in nature under Golaknath case, Minerva Mills case, Keshavnand Bharati case, A.K. Gopalan case. So under which of this case is the Supreme Court held that the fundamental rights are amendable in nature? So the correct answer is option 3, Keshavnand Bharati case. Keshavnand Bharati case. Thank you, friends. Thank you from Defense IAS Academy. I hope this session on fundamental rights and the important questions that can come from the fundamental rights is useful for your UPSC exam preparation. If you like the video, please do share it with your friends, and also please do subscribe to the channel Defense IAS Academy. Thank you.